Oftentimes, there are clients who say, well, I don't want to take it back. They didn't fix it the first time. Why should I bring it back? Each time you take it in, it's documented. Each time you get that document, that's more evidence for us to be able to argue on your behalf. Hey, it keeps happening. This is what's going on. This is when it took place. Here's the mileage. Here's the date. It's occurring still, this defect. The more repairs you have, it helps us build a stronger case.
Welcome back to Lemon Law Unpeeled, the Lemon Law podcast. Today we're going to be debunking some common myths that consumers believe about lemon law and separating fact from fiction to help you better navigate the waters should you find yourself in the position where you have a lemon. So as I stated, I'm Emma, and then I have my two co-hosts here with me today as well. I'm Courtney.
And I'm Steve.
So today we want to talk about, let's first discuss just common top myths that consumers believe about lemon law. One big one that stuck out in my head that, Courtney, I'll let you tackle, is a lot of clients ask us or call in and say, hey, my vehicle is at, let's say hypothetically, it's a New Jersey case. My vehicle is at 23,500 miles. What does this mean for my case? Is it going to hurt me if I go past the 24,000 miles, or what does that really mean?
Yeah, that's absolutely a big one, Emma. So the answer is no, it is not going to hurt you if you go past those 24,000 miles, as long as you have met the requirement per state, which in New Jersey is that the issue has to have been subject to repair 3 times within 24,000 miles and then continue to exist. So you can certainly go beyond the 24,000 miles as long as the vehicle was subject to repair at least 3 times within that period of time. However, it does come into play a little bit in the sense that if you have 80,000 miles on your vehicle, we're practically speaking not going to be able to get that vehicle bought back, because that's just going to go to the egregiousness of the issue. And if the vehicle's defect is that egregious that it would rise to the level of the lemon law, meaning it is rendering the vehicle useless, valueless, extremely dangerous, you're not going to be able to put that many miles on the vehicle. So the less miles that are on there, the better. But it is certainly okay if you are beyond the actual guideline of how many miles you are allotted per state, as long as the vehicle was subject to repair the requisite number of times before you hit those miles.
Right. So usually, as I explain it, is that the law just wants to see that you had those visits or that problem within that time period. It's not the actual limitation that you have for bringing a claim, which kind of brings me to the next myth that a lot of clients, either, I shouldn't say myth, but just a piece of lemon law which they don't quite understand that I'll let Steve tackle, is that they'll often call and say, hey, well, my vehicle has more than 24,000 miles on it, but it's less than 2 years old. Do I still qualify for my visits? And so, because the laws often say 2 years or 24,000 or 2 years or 18,000, but I'll let Steve talk about what that really means and what is required when you're having these issues.
Absolutely. So every state has their own requirement that the law will cover a certain period of time when repairs occur. So for example, going with Wisconsin is 1 year after buying the vehicle. So the repairs that occur within that first year are covered by Wisconsin's lemon law. So that means during that first year, you want to have 4 repair attempts for the same defect, or you want to have your 30 days out of service to qualify. Repairs that take place after the year of ownership are not considered under that state's lemon law. But some states, such as New Jersey, will say either the first 2 years or the first 24,000 miles, whichever occurs first. So sometimes you have to kind of monitor your mileage to see whether or not you've had your 24,000 miles prior to having your 2 years of ownership. So that can vary on when your repairs will qualify or not qualify under New Jersey's lemon law.
Right. So even if a client has 3 visits within 2 years, but the third visit was at 26,000 miles, unfortunately that disqualifies them, right? Because it's whichever one happens first. As I usually explain it, it's kind of like a warranty, right? You have to have both of them present, even though the statute itself uses the word or. What matters is the words that follow after, which you aptly pointed out, that it's whichever occurs first. So whichever one hits first expires it. Additionally, Steve, I'll let you talk about too, where some clients will call in and they'll say, okay, well, I didn't have the same visit multiple times, but this is clearly a problematic car. And even the car dealership said to me, or the mechanic said to me, this car is a lemon. You've had so many issues and so many problems. I'll let you talk about what the law allows to happen versus what they don't allow to happen.
So again, every state is very specific on their requirements, and it comes down to nuances. Going back to Wisconsin as an example, what you need to have happen is 4 repair attempts for the same defect, not just a general defect. Just an engine issue is not enough. The check engine light is more specific. Engine misfiring is another issue. You got to look at the same type of issue, not just a general issue with the engine. Whereas with the 30-day requirement, your vehicle needs to be out of service for a total of 30 days. That can be through one repair or through multiple repairs, but it needs to be out of service for 30 days, and that could be for different issues.
Right. It could be for different issues as long as you have a cumulative total of 30 days out of service. But as it rolls along, right, it generally you have to have, if you have multiple visits for the same issue and they all add up to 30 days out of service, or you have multiple visits where you're in for the radio and you're also in for an issue with your tire pressure light, and then you return again for the radio. There does need to be that common thread throughout them to connect all of the visits, but you can have a cumulative total of 30 days for the visits in order to be able to qualify. Because a lot of clients, the example that I give them is you can buy, a brand new BMW, and the minute you take it off the lot, your engine goes, then your transmission goes, then your radio. As long as each of those problems are fixed within a reasonable amount of time or number of attempts, I wouldn't be able to help that client, right? That client wouldn't have a case because you have to be able to show repeated visits for the same issue, because in a sense, then they have breached their warranty. They have not been able to fix a defect within a reasonable amount of time. And that's what triggers the Lemon Law. In one-offs, individual issues, unfortunately, just don't qualify, which kind of brings us into our next topic of, so what does qualify you? So Courtney, I'll let you talk about, because every state has a little bit of a different time period requirement for when the vehicle has to be in. New Jersey has a different cumulative total of days. So I'll let you just generally, though, talk about what is the common thread between all of these states' lemon laws. What should consumers be looking for to know when they do have a lemon law claim?
Yeah, but generally what you want to see is that the vehicle was back to the dealership multiple times, starting fairly early on for the same problem, and that problem has to be of a certain caliber, and the problem has to continue to exist. So that kind of brings us to one of the other big myths that I think people often think is, oh, hey, my vehicle was back 3 times before 24,000 miles. That's a lemon, right? Automatic, right? Or in Pennsylvania, my vehicle was back before the 12,000 mile mark and then thereafter 2 more times. So a total of 3 times. That's what the lemon law says, right? So I automatically get a new car, right? And unfortunately, no, because not only does the vehicle have to be back a certain number of times, generally 3 within a certain period of time or starting within a certain period of time, but there's 2 other big requirements. One, the problem has to be of a certain caliber, meaning it has to, generally speaking, it's a little different per state, but generally speaking, substantially impair the use, value, or safety of the vehicle. And what some cases have actually taken that to mean is the vehicle has to be completely useless, completely valueless, or so dangerous that it is essentially a death trap on wheels. And that's a term of art handed down in one of the cases in New Jersey, actually. So it has to be a very egregious issue. It can't be a radio, a temperature sensor, a noise. Generally, it does have to be an engine or a transmission defect that is literally preventing the vehicle from driving from point A to point B. Now, caveat, we have had, in the rare cases, some vehicles bought back for infotainment type issues. I actually just had one a few months ago, but I was honestly quite surprised about that, and that is not the norm. And then the other aspect is the issue does have to be ongoing. So even if your vehicle was at the dealership for 9 months, but you got it back last week, we most likely are not going to be able to get the buyback because most states do mandate that the issue continue to exist, meaning it has to still be happening and not repaired.
Sort of issue, right, that we often run into is whether if the vehicle's ultimately repaired, you don't have a lemon law claim. Legally speaking, though, within the law, usually it doesn't exactly say if it's ultimately fixed, you don't have a case, right? It just lists you have to have 3 visits and it continues, or 4 visits and it continues. So often it's like, well, what does that mean, right? Does it mean that I only need 5 visits and I'm done? And what I usually explain to clients is that there's no automatics under Lemon Law, right? There's lots of different issues that come into play because of the third prong of it, right? That it has to be a substantial impairment. And where the argument comes in, if it's ultimately fixed, is often the defendant or the manufacturers will say, well, if it was such a substantial defect, how was it able to be fixed, right? We repaired it. It's been 6 months since they had the problem. This vehicle is no longer a hazard. So there's no reason for us to buy it back, but, we can give them money damages or something of the like, right? It's not anything that's that's set in stone, but as I tell clients, as a practical matter, but, practically speaking, it can be difficult to get the repurchase if it's ultimately fixed. But I think everybody can agree it also depends on the manufacturer, right? Some manufacturers are very strict on that, and other manufacturers will still buy it back, even if it is seemingly repaired. They just want to see that it meets the presumption. Another sort of issue that we run into too is some clients will think because they purchased their vehicle used that they don't qualify for Lemon Law. And Stephen, I'll let you talk about that, how each state kind of dictates whether they will accept a used car into the Lemon Law statute or whether it explicitly says no.
Absolutely. So every state, as we've been talking throughout this session, is different. It would be great if they were all exactly the same. Our jobs would be a lot easier if all the statutes were the same, but unfortunately, every state in their own wisdom have different requirements. Unlike Wisconsin, where used vehicles do not qualify, a state like New Jersey, they do qualify, and it is expressed in the statute that even though you bought it used, it does qualify for the state's Lemon Law. So that's why it's important when you're buying your car, if you do have a concern about, will this qualify in the future? Hopefully you don't have that issue, but if you do, make sure you know your state's requirements, because sometimes it does not apply to your vehicle, even though it seems like it should.
Right. It's very strange how that works, right? Because Colorado, and we can use Colorado and New Jersey, because I know you and I recently had to tackle this issue with Colorado and leases. So Colorado says leases don't apply under Lemon Law, which makes very, very little sense to me. And it is more of like the statute itself just says purchased. So they're taking that to mean that leases don't qualify as opposed to it saying it outright. So that can get kind of complicated too. But if you look at Colorado versus New York, for example, Colorado says leases, don't qualify under Lemon Law, whereas New York says leases only qualify under Lemon Law, which is all very confusing and can make it a little complicated when it comes to whether you're deciding to purchase or lease a vehicle. For example, I have some clients in New York that when we're all wrapped up with their case, and let's say they had a lease or something and we couldn't help them or some sort of situation like that, I'll usually kind of nudge them and say, hey, if you're close to Jersey and you want to lease your next vehicle, pop over to Jersey to do it. Because New Jersey is totally different with leases. New Jersey is so soft on leases, I guess would be the term, that there even is case law in New Jersey that says that once your lease is up and you've surrendered your vehicle, you still have a Lemon Law claim. You don't give up those rights, which, Courtney, I know I kind of talked about it, but I'll let you sort of discuss that and how New Jersey works with leases and used cars, because New Jersey is a totally different ballgame when it comes to that as compared to states like Colorado and New York.
Yeah, I was actually just about to say the exact same thing. It doesn't happen often, practically speaking, but there is case law in New Jersey that says even after you've surrendered a lease, you do still have a Lemon Law claim. So you could potentially still get back all of your monthly payments and down payment under a lease, even once you've already surrendered the vehicle. So New Jersey is great in terms of leases, and leases do work just the same way as purchases. So you're still going to have Lemon Law, you're still going to have breach of warranty. Unlike in New York, where a lease doesn't qualify under breach of warranty and only qualifies under Lemon Law, which makes very little sense to me. And it's actually exactly what Steve said. Sometimes you think you're going to have these protections because that's what common sense would dictate. And unfortunately, the law does not always follow what we would think of as common sense. So in New York, you're really quite limited because you only have Lemon Law, which is going to be a much smaller threshold. The vehicle has to be subject to repair 4 times within the first 18,000 miles or 1 year. So it's really tough to meet that. And if you don't have breach of warranty, then that's all you're left with it's not really real great if you've leased your vehicle. Whereas New Jersey, like we said, very lenient toward leases. They work the same way as purchases. You're going to have lemon law and you're going to have breach of warranty available to you.
Yeah, it can get confusing. And then to throw an even bigger monkey wrench in, so there are about 8 states in the U.S. that also have a used car lemon law. New York, New Jersey being 2 of those states. It's obviously not common. It's only in 8 states, but it applies to used car dealerships, and any dealership that sells a used vehicle has to give a lemon law warranty with it when selling the car. Those cases, similarly to leases in New York, are really difficult, right? You have to have multiple visits within a very short period of time, usually no more than 90 days. We have handled some of those cases. They're just so difficult and the threshold's so high that they're pretty few and far between. And then the next kind of monkey wrench that comes in, especially with used vehicles, and Courtney, I'll let you talk about statute of limitations, right? New Jersey and PA are very flexible on those. And then you have states like New York and Georgia that are very strict.
Yeah, absolutely. So talking about statute of limitations, sometimes it's really not something that we worry about too much. States, however, like New York, it does have to be within 4 years of purchase of the vehicle. So we can absolutely get into a hairy situation there where perhaps an issue isn't starting right away, starting later on. And a client thinks, hey, look, I don't even have that many miles on this vehicle and I just started having this issue. But unfortunately, sometimes we might have to turn them away or let them know that there's not much that we could do to help, because once that statute of limitations has ended, there's not a whole lot that we're going to be able to do.
Right. And that kind of brings us to the next sort of topic that I wanted to talk about in terms of how consumers can protect themselves to bring the best lemon law case they can and not waste any time in actually doing so. So actually, as Stephen and I had a client that we spoke to in Maryland probably like 2 days ago who was really upset about his vehicle, saying that it was a known issue within his truck and they sold it to him anyway, and that the problem did happen before 18,000 miles. He just didn't bring it back. And so, Stephen, I'll let you talk about the importance of not waiting, right? If you have an issue, if you have a problem, definitely bring it back, because as you can, discuss, that client and his rights under lemon law were extinguished by not doing that.
Absolutely. So oftentimes there are clients who say, well, I don't want to take it back. They didn't fix it the first time. Why should I bring it back? Each time you take it in, it's documented. Each time you get that document, that's more evidence for us to be able to argue on your behalf. Hey, it keeps happening. This is what's going on. This is when it took place. Here's the mileage. Here's the date. It's occurring still, this defect. So it's important to, even though it might be frustrating to keep going back to the dealership, the more repairs you have, it helps us build a stronger case. And as long as we can still argue that it is an ongoing issue through these repairs that continuously go on, that's what we need. And it's kind of important to remember documents are crucial to us. We need these documents. So please don't just, say, oh, they gave me a document, I'm not sure what it is. Always try to keep your documents together. So that way, if you ever have this experience, you have them ready and we can absolutely take a look at them and tell you where you kind of stand and what we think your case has going for you or what your weaknesses are even. But documentation is crucial. So that's why we always say, if it's still going on, please take it in for another repair attempt so that way we can still establish that the issue has not been corrected.
Exactly. And we always tell clients, read that repair order before you leave. Make sure that narrative is correct. Make sure the days in and days out are correct. Because I've definitely had it before where I had a client in New York who, hers was a little different. She said it was out of service 30 days due to, it was a hybrid vehicle and it was having battery issues. And then she didn't want it back. So she just refused to take the car back. So as we had explained to her, those days that you refuse to take the car back, unfortunately don't count, right? It has to actually be out of service for repairs. But then when she finally did pick it up and get the service record, it only showed 15 days out of service, where she was like, no, I have text messages showing when I dropped this off. We're still actively working on that. We're still trying to use those text messages to help show those dates. But again, that's why it's so important that you review the material before you accept it and you make sure that everything's in line before walking out that dealer. Because if you go back after the fact, they're going to say that, oh, they don't remember, they don't know. Whereas you want to, when it's fresh in their minds, have them open an addendum or write an additional repair order clarifying the correct issues or days out of service should you run into that problem. And kind of similarly along the same lines, Courtney, I'll let you talk about this, how some clients also stall bringing their claim because they're going to give the dealer another opportunity to fix it, which is also a time waster, right? Especially if you are in a state where you have to send a final repair attempt, you're kind of shooting yourself in the foot in terms of when that final repair attempt counts and when all of that starts.
Yeah, you definitely just want to bring the claim. Once you've met the requisite number of times to be able to bring a claim, you definitely want to go ahead and do that because it's not an overnight process. It's going to take us generally at least 60 days to hear back from a manufacturer after we file a claim. And you can continue to get more repair invoices within that period of time. So don't wait to get another one. Go ahead, get the ball rolling. And then you can always send us another one and we'll continue to supplement the claim. And in that way, if once the manufacturer is actually looking at that claim, your claim is actually on the top of the pile that's on their desk and it's still out of service, that's going to bode even better for you. That's going to give us a better chance of being able to get the repurchase. And along the same lines of just letting your vehicle sit at the dealership if the repair has been completed, it's worth it to say, make sure you're calling the dealership to follow up on your repair if the vehicle has been out of service for a while, because I have seen it happen. And in fact, I just had a case like this where the vehicle was actually sitting there for months after the repair was completed and the clients were never called by the dealership. And here they are thinking they're definitely going to get a repurchase. The vehicle's been at the dealership for 6 months. And when the manufacturer contacted the dealership, they said, no, it's actually been fixed for 4 months. But they got mad at us at one point and said, I've hired an attorney, don't call me, I don't want this car back. And I think some liberties were very much taken there. I don't think those were their exact words, but I think there was a little miscommunication between our clients and the dealership thought, it's sitting here fixed, but we're not going to call them. And our clients were very much expecting a call. So it's always worth it to call them and follow up and say, hey, look, what's going on with my car? Is it fixed? Is it not? What are you waiting for? I've also seen it happen where they're waiting on parts and the parts came in and then the dealership actually forgot that your car was even sitting there on the lot, so never put the parts in and called you to let you know it was ready. So definitely stay on top of the dealership. I usually say rule of thumb is call them once a week and just check on the status.
Right. And dealers often too, well, at least lately what we're running into is they are making buyback offers themselves, right? Oh, don't worry. You don't need a lawyer. You don't need to get involved in lemon law. We'll repurchase the vehicle. We'll buy it back from you. But Steve, I'll let you talk about how technically a dealership can't do a lemon law buyback, right? Lemon laws apply to manufacturers and dealerships are independent contractors. So it, again, usually, does not benefit the client.
So yes, each state's lemon law applies to the manufacturer and not to the dealership. So these dealerships are not owned by manufacturers. They are not owned by Ford or General Motors. They are their own separate entity. And so when they're saying they're going to buy back your vehicle, they're actually meaning that they're going to trade in your vehicle and you might lose what you've put into your car that you currently have that's not functioning correctly. You may not be able to get all your equity back. You may end up having actually a higher loan than you had previously. What they are doing is trying to help themselves get out of the situation and not get involved by just saying, oh yeah, we'll buy back your vehicle, but it's really just a trade-in. So that's why it's best to go through this process of seeking out a lemon law claim against the manufacturer who can actually repurchase your vehicle, whereas trying to deal with the dealership, they might be telling you one thing, but they really mean something else.
Right. And it can really end up hurting you in the end because you're, like you said, you're starting over on a loan, you're losing all that money that you had put into your original vehicle. And then that vehicle itself that should be branded a lemon will just get passed on to the next consumer as opposed to being properly branded and things of that nature. So whomever does buy it next, usually at auction or something, knows about that and is doing that fully aware, right? They're purchasing the vehicle fully aware that it was branded a lemon. So that's why it's always super important to know your lemon law rights. Every state's attorney general's office usually has a pretty comprehensive page on at least the length of the lemon law, the number of visits that you need, whether it's new or used, leased, things of that nature. So that's a really helpful resource when you're purchasing a vehicle to know your rights and when you need to get it in for repair. Unfortunately, there's no surefire way to not get a lemon. You can research, you can go to online forums, but it can happen to the best of us. So it's best to just be well armed with research and information. The Better Business Bureau, or the BBB, is another great resource that has very comprehensive summaries of each state's lemon law. when it comes to determining where you fall. And additionally, our intake line. We give free consultations to clients, even if it's premature and they're not ready to get started yet. We will help guide you, tell you what is needed, what additional visits you need, or what additional action you can take to preserve and be able to bring your lemon law claim in the future. Our intake line is 1-833-4-CAR-LAW. And like I said, all our consultations are absolutely free. And then there's also our website, lemonlawcar.com. We have state pages in accordance to the states that we practice in. There are also a really good resource for consumers when knowing what to watch out for and when they want to start bringing their vehicle in for problems as opposed to waiting. And with that, we want to thank you all for listening today, and we'll see you next time.
See you soon, everyone.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.